ownership, and where we get that ownership from is from what we would refer to as the vesting deed. And that's just the last warranty deed or quitclaim deed that was filed in the county records. And when you see that commitment, the Schedule C or the Schedule A of the title commitment that we put out, that's probably one of the biggest pieces to look at. It's that first page of the title commitment, and it's on item 3. It's going to tell you, as of the effective date of this commitment, title is vested as, and it's going to give you that language. And we take that language directly from the deed filed in the county records. And the only way to change that vesting is through a new deed. And a lot of people get that confused, and they say, well, there's a deed of trust. They took the last mortgage out with both husband and wife. Why does it only say the husband's name on title? This is why, is because it's possible that they purchased before they got married. It's possible that they simply purchased it as a married man or a married woman. There's a lot of variables that go into that. And so what we're showing is exactly what we find of record. And then if you wanted to change that for any reason, a new deed would need to be signed. Okay. The other big one is when you see that come across and it's in the name of a trust. Okay. And that's going to tell you, again, it's going to say exactly how the deed is written, but it's going to normally read out Josh Ellison as trustee of the Ellison Family Revocable Living Trust or something similar. And that's important for you to know, because if you come across a listing and they tell you that the home is owned in the trust, then you need to make sure that the seller is actually the trust. The seller is not the individual. A trust acts as an entity. It acts just like very similar to the way a company or an LLC would operate. And so that's important to know that. And the two pieces to a trust are obviously the trust itself being revocable or irrevocable. And revocable just means that the trustees have the power to get rid of it. Okay, they can, at their power, they can say the trust no longer exists and everything is now back into my individual name. An irrevocable trust, you see those a lot less often, and those those require some special action or circumstance in order to revoke and in order for them to go away. And again, those are much less common. You don't see those all that much. Okay. But the trust itself, if you do come across a property that's in a trust, what you're going to want to do is get a copy of the trust from them. And many times your sellers are going to say, well, the trust is 50 pages long. I don't want to give you the entire thing. We have some options for that. If you run into that situation, let me know. We've got a thing called a trust certificate that they can fill out that essentially they attest or fill in an affidavit regarding all the information in the trust. But we need to review that because we have to establish, is it revocable or is it irrevocable? Who the trustee is, and more importantly, what the powers of the trustee are. Because they may have named 4 different trustees, and if that trust says that all 4 trustees have to act, if you get a contract signed by only one trustee, you don't have a valid contract. You've got to make sure that you've got those people, the people that are executing your documents, have power to execute documents on behalf of the owner of that property. So one other thing to keep in note is that even though I may be Josh Ellison is the trustee of the Josh Ellison Trust, I am still not acting as an individual. I don't have power as an individual. I only have power as the trustee. It's still an entity, and I only have the powers that trust document has given me. Okay, so that's the important thing to remember. Again, if you're going to take a property in a trust, we'll do most of the heavy lifting for you. We don't need you to read through it and establish, who is what. Normally I would say get a copy of that and then, send it to me. I'm more than happy to take a look at it. If you're at a listing appointment and they say this and they say, here's the trust, send me a text. I'm more than happy to review it. It only takes me a few minutes to tell you the basics that we need to know. Okay. And then again, we're going to have some documents. We're going to either need the trust, and we're going to have a trust certificate that needs to be filed. So Okay, so we've gotten kind of what those things are, and the most important thing about my job is the title commitment. That comes out, and you've got a seller, and suddenly the vesting on Schedule A number 3 doesn't match what you expected it to match. Okay, and the couple of things come into play. One, it could be in a trust, and we've discussed that. The second would be if a prior spouse is listed, and they are likely to tell you, well, I was awarded the property in divorce 6 months ago or a year ago or whatever, and so it's mine. He doesn't have anything to do with it.
So the vesting section is on Schedule A.
It's Schedule A, item number 3.
Okay, the Schedule A, including some stuff, right? The sales price and effective
Correct.
date and like a
Yes,
loan amount and everything. And
that is correct.
can you explain that section, I mean, the Schedule A a little?
I certainly can. So Schedule A is the first page of our title commitment, and it's going to say the purchase price. What it's indicating to you is the amount of the owner's policy and the names that we have in our file that policy will be issued to. Typically, that's going to match your buyer's name directly from your contract. Okay. And we're going to confirm that with either the lender or with the buyer prior to closing to make sure that, yes, this is how they want this style. They want it husband and wife, or they just want it, many times they want it wife and husband, or they may not want that verbiage at all. They want, something else. So we will confirm that with them. It's also going to have the loan amount and the lender. If there's a lender involved, it'll talk about the lender's title policy, and when we talk about that, you'll hear us talk about the mortgagee clause, and that's what we're referring to is the way the lender wants their name styled on their title policy. And then it's going to talk about the loan amount. That's the policy amount coverage that they want. And then item number 3 is it's going to indicate to you the effect, again, the vested owner as of the effective date. And then item 4 is going to give you the legal description. Now, the important part about that is the legal description is what we go by as a title company. So many times we'll have an address variance. The lender will come back and say, hey, this says 123 Main Street, but your title commitment says 123 Main Avenue. And again, we're taking our address in our file directly from your contract because we don't insure an address. We only insure a legal description. So if they come back and tell us this is what it's supposed to be, we are more than happy to change that. And that's a common thing that you'll see. But that's why the address itself is not on Schedule A. It's only the legal description. And the one thing I didn't mention is at the top of that document, it's not a numbered item. It'll say the effective date. And that always draws question because someone will say, well, it's November 9th and your effective date says October 25th. Why don't you update this? Why are you giving me an outdated document? And the effective date is not the date that we issued that commitment. The effective date is the certified date in the county records. So all the county records are certified every day or every, they stay in the rears. They're usually about 2 weeks in the past of documents they've imaged, they've reviewed for accuracy, and they've certified. And so they put out a date. And so our computers, when we actually pull those documents, that's as far as we can go. That's as far as we can see certified records. And so that's what that effective date is. And so let's say someone, for instance, got a divorce and it was filed yesterday, or it was finalized yesterday, and their attorney did a really good job and got a warranty deed signed and filed the deed in the county records. And you ordered title with me 2 weeks ago, and I've sent out your title commitment today, and the title commitment still says the ex-spouse's name on it. That is because the effective date is before the recording date of that new deed that was just filed. So we're only going to see records, and that commitment is only going to reflect actions in the county records as of the effective date of that title commitment. So, any questions so far?
How long normally does it take to get like a divorce decree after the judgment? And if the title company is asking like that paperwork, how do you normally handle?
So a divorce decree it really varies. That's going to depend on the family courts and how, what their backlog is. However, what we're going to ask for on a divorce is, especially if they're impending, especially if it's a recent one, we're going to want a court signed final divorce decree. That means that final decree that's got the judge's signature on the final page, and it's been stamped and it's recorded in the county records. Okay. Many times we'll get people that are in the middle of a divorce and they've got a summary judgment, they've got all this paperwork that they're in the process of, but they don't have the final decree. And that final decree is what we have to have. So
Okay.
that's the important part. The other thing to note with the divorce is just because the divorce awarded you the property does not mean that when that title commitment comes out, it's going to show, it's going to reflect that change. So Josh and my spouse, Monica, got divorced. When I pull title work, unless something else is done, the title work is still going to show Josh and Monica. We have two options to cure that. The most preferable option at that point would be, let's prepare a deed and let's have the ex-spouse sign a deed, and then we record that in the county records. A good divorce attorney will do that as part of their final wrap up of the document of the divorce. But I would say, I hesitate to say there's not a lot of good ones, because we find it not done more times than not. Almost always, if they've been through a divorce, we have to prepare a deed and try to track down the ex-spouse. Now, the other option we have is we can order a certified copy of the divorce from the courts, because remember, the divorce is filed in court records, not property records. So we would have to order a certified copy of that divorce, and then we can file that copy in county deed records to act in lieu of a deed. The problem with doing that is county deed records are public record. And so if you've had a really messy divorce, you suddenly shared that with the entire world for everyone to view. So most people don't, we really try to avoid doing that if we can, but if there's no other option, you've got a estranged spouse that's just not willing to do anything, but you've got a final divorce decree that awarded you the property, we can do that in alternative. Okay. So that kind of covers if we're in a trust, we know what we've got to do there. If we've got a prior spouse listed, we know what we have to do there. And then obviously the way we handle a prior spouse is similar to the way we would handle another party. Let's say we have Joe, my neighbor, helped me buy a house and I put him on the property, or I've got one of my kids or my siblings or any of those things. In order to remove another party from that house, or for that matter, to put them on to that house, if that was the need, then a deed is needed. Okay. When we're talking in Texas, if you come across someone that is on title to a home, whether or not their spouse is listed or not, in almost all cases, we are going to need the spouse to also sign the deed, especially if they live in the house. So in Texas, we have two things that affect us here. It's homestead rights. So if you live in the house, you have a right to the home by default, even if you're not a named owner. If you pull the vesting deed and it just shows Josh Ellison, if my neighbor Bob or if my buddy Bob lives with me and I go to sell the house and he's living in that house, Bob needs to sign the deed. People say, well, hold on, well, Bob doesn't own the house. I pay the mortgage. Bob lives in that house. And if that's the only property he has in the state of Texas, if he doesn't own any other property, by default, Bob has homestead rights to that property. So that's really important when you're talking, especially on listings, when you come up with someone and you might end up with, you've got someone living there permanently and that's the only home they live in Texas. You want to call us and make sure that we clear up, any issues. And same thing with the deed. We're going to need those people to sign.
What if Bob third party is married and his spouse live overseas? How it's gonna happen?
So it gets really complicated. So if
It's complicated.
Bob living in the property, but he's not,
Married.
his spouse doesn't live there. So you've got two things that run here in Texas. You've got homestead rights, which is how Bob has rights to our property. And then you have marital rights, right? My wife owns by default 50% of everything I do, unless I have some extenuating circumstances or I can prove that it's sole and separate. And there's some very stringent requirements to prove that. In that case, in most of the time, I would think Bob's wife is probably not going to have rights because Bob only has rights because of his homestead. He does not have any, and he doesn't have ownership, and she wouldn't have marital rights because she doesn't live there and he doesn't own it. He only has a homestead right to the property. He doesn't have ownership. He really has homestead rights.
Oh,
If that kind of makes sense. That would be a very unique situation to address, but certainly one that we would want to address up front. But my inclination, I'm not an attorney, but my inclination would be that we would need Bob to execute. There's a lot of factors that go into that as well. So in the state of Texas, your homestead is by default. If you only own one home, it's by default the home you own. You can rent an apartment and own a house down the street. And even if you don't live in that house, even if you have renters in that house is your homestead because it's the only property that you own in Texas. So the homestead protections protect us a lot of times, but they also can make transactions a little bit hairy depending on the situation. So you definitely want to bring those up. Status of the third party. So again, if we've got a third party, we've got Bob and title. We need to address that. We want to see if Bob is in fact married. If they're a named title holder, almost always you're going to need the spouse. If we have a spouse that's overseas, we can certainly arrange for mobile notaries. They've got we've got alternatives for that if that comes up. I do quite a bit actually outside the country, but there's some certainly some circumstances that we have to work through when we do that. So if we do want a new vesting deed, so even if you've got a client that comes to you and says, I really want, I bought my house with you last year and we didn't add my friend Josh here on title, but I really want to put him on. He's been a really good friend. We can certainly do that. If it's part of a transaction that we closed, I can usually have my doc prep attorney do it and help them through the recording process. If you have that happen and it's not a transaction we've ever closed with, I am more than likely going to refer you to a real estate attorney to help you. But I can't handle that directly because it's not part of a title insurance transaction. But let's see if there's anything else I missed. Do I have any questions?
any questions, guys?
I know it's the most interesting topic on earth. So I see a lot of money kind of like, that's why we have a title company to let me deal with that. And you guys do what you do well. So
Okay.
Y'all have my information. Again, if you did not get my wonderful Wednesday email last night or this morning, please let me know. If you just don't want me to send it to you, let me know. I'm happy not to do that, but I really do try to make it pertinent information. I try to make them short and sweet. I don't typically get all flowery with them. I will, say hello, give you the information. And I've got a lot of clients that they tell me that they've got their desk area lined with emails from me because it's things like this that when you don't normally need to know it, but when that question comes up, it sure is nice to have the information available and handy there for you to reference there. So, but again, I'm always available. My cell phone number is on everything. Call or text me anytime. Seriously, you're not going to bother me. If I don't want to talk to you, I'm not going to answer. But I told your boss here, Sean, I said, try me. If you don't believe it, just try me sometime. I'll be more than happy to talk to you.
Okay, don't go yet. I mean,
Okay.
I have a question. What's deed transfer taxes? What is deed transfer taxes? When is due, and what case?
Okay. So in the state of Texas, we do not have deed transfer taxes here. We don't have recording taxes here. Deed transfer taxes account for about 30 out of the states in the US, and those will, depending on what state you are in, some states will tax the deed itself, which is on the consideration of the deed or the purchase price. Some states tax the mortgage, so the loan amount, And then some wonderful states such as New York will tax both. If you go into the state of New York and you try to do a refinance on a $500,000 property, you will pay about $25,000 in taxes.
Okay.
So they are ridiculously high. Florida has a mortgage tax, but they don't have a deed tax. It just really varies from state to state. But in Texas, we do not have any deed or mortgage taxes.
Okay.
The only fees we have in Texas are recording fees, and they vary by county. And typically they are calculated by a set number for the first page and then another set number for every page thereafter.
Okay.
Yeah.
All right.
All right, guys.
Any question? He's busy and he gotta go. Okay.
All right.
Okay. Thank you for joining our meeting. And we're gonna have a year-end party on 10th of December. Okay, you and Terry is invited. So I'll give you an update. Okay. All right.
Wonderful. Sounds great. Have a great
Thank
week,
you,
everyone. If you
Josh.
need anything, reach out.
All right. Bye-bye.
Josh, thank you.
Bye-bye.